Hi, Gita.
Hi Rashid, how are you?
Well, thank you yourself.
Fine, thanks.
Thank you for being with us here today. It's a pleasure to have you. For the audience, my name is Rashid. I'm the host of today's episode. I have with myself Gita, who is a prominent family lawyer and the founder of the Bedfordshire Law Clinic. Yeah. Before we begin, we would
Mhm.
like to mention that the contents of this podcast are for educational and informational purposes only. They do not constitute formal legal advice. The facts of each case vary. If you have a legal query, please obtain professional legal advice valid to your individual circumstances. Vera, the host, or the guest would not be liable for any damage or loss caused. To begin with, Gita,
Mhm.
have you heard of the couple who mistakenly got divorced earlier this month?
I think Rashid, every family lawyer and one who probably isn't has probably heard the case of Mr. and Mrs. Williams. So, as you've rightly pointed out, this was a case where a member of staff at Vardags made a online application using the court portal system and made an application for a final order for divorce. But unfortunately, they made the application on the wrong client matter. When the mistake came to light, Vardags made an application to get the order set aside on the basis that a clerical error had been made. However, the judge refused to set the order aside. The case in itself has gained a fair bit of publicity. I'm aware that Vardags have made comments to the effect that the judge made a bad decision. But I think, the case in itself, is a warning to all family lawyers and practitioners in general, to ensure that they're more vigilant, they're more careful when they're conducting work on client matters, making sure it is in actual fact the correct client matter, in accordance to the client's instructions.
For the audience, yes, you provided a little context. So the couple in question had been married for about 21 years and
Mhm.
had, I think, some version of a trial separation earlier this year. So this is a couple still kind of making up their mind, and divorced now.
It's my understanding they were in the process of resolving the financial matters. So, you know, they had not actually given instructions to apply for the final divorce because they were in the process of getting the finances sorted out. So, like I said, the final order was made on the wrong client.
You founded the Bedfordshire Law Clinic.
Mhm.
Can you tell us a little bit about the story there? Kind of your motivations for going down this path.
So, the Bedfordshire Family Law Clinic was launched on the 19th of April 2021, and it's a pro bono clinic that gives free advice to members of the public in respect to all family matters by phone. One of the reasons that the clinic was set up was due to the COVID-19 pandemic. During that period, Rashid, I very much felt as though the floodgates had opened, in terms of the number of inquiries we were receiving, in respect to clients who were experiencing domestic abuse. They were in lockdown, and that abuse was being experienced from their partners, from their spouses. And, they were fearing for their safety, in the family home. And, let's face it, Rashid, your family home is supposed to be viewed as a safe haven. I had to turn a lot of those clients away because most of the clients couldn't afford to pay privately. They were potentially eligible for legal aid, but they were coming back and saying that they were finding it very difficult to access a legal aid lawyer. So, during lockdown, when I was working from home, I put my thinking cap on, thought of, how I could possibly help, how I could possibly give back something to the community. And that's when the idea of, potentially setting up a law clinic came about, did the relevant research, looked at, all the red tape and the hurdles I would need to bypass in order to get this set up. And then, yes, it was officially launched on the 19th of May. And I kid you not, Rashid, when I say that, before its launch, we circulated the information about the clinic, to various organisations. I made contact with my contacts, explained that, this clinic was going to be launched. And, a week before the launch, I had various organisations contact me, saying that they had clients, who needed advice and whether, they could pre-book an appointment. In its initial 3 months, the clinic was extremely, very, very busy. So that's how it came about.
It's a fantastic initiative, and must require so much bravery and so much kind of effort to kind of, set it up and kind of go down this. Also, sacrifice at your end, right? Because it's a lot of time which you've invested to set it up.
Yes, I mean, there was a lot of research, working at midnight, once I finished my client matters, reading up, and yeah, making various applications to kind of get permission. But I think, at that point, like I said, it was something that I was extremely, passionate about. And, like I said, it might sound like a cliche, but one of the reasons, I went into law was to help clients, was to help them access, legal advice. And so, that was also the driving force behind that, because I'm a great believer that, legal advice is something that should be available and should be accessible to all. So yeah, so it took quite a bit of effort, quite a few stressful days, but yeah, managed to finally get it launched. So yeah, I'm glad.
There was a study by the Law Society, I think the most comprehensive study of its time. I think
Mhm.
it's last year, maybe year before.
Mhm.
Essentially, what it said was 1 in 5 adults have had had a legal challenge over the past 5 years,
Mhm.
and 50% of those who did never accessed professional legal advice.
Yeah.
And the rationale was, a, of course, access is the process of accessing. Maybe lawyers are considered intimidating in certain circles, but also secondly, affordability. A
Mm.
lot of people want to use them, just too expensive to use.
Mm.
In your clinic, is there any kind of is there any question or case you receive the most of?
So initially, when the clinic was launched, we got quite a few inquiries in relation to clients experiencing domestic abuse and wanting advice on what protective orders were available to secure their welfare and safety. As the clinic has moved on, one of the most popular inquiry usually revolves around couples who are thinking of getting divorced. They want advice about what the divorce process entails, and they want to know financially, what they are entitled to by way of a financial settlement. So yeah, those inquiries in particular are very popular.
Could you shed some light on who can access a law clinic, and is there a criteria they need to meet to be
So
able to eligible for that? Sorry.
yes, sorry. I mean, when the clinic was first launched, the main priority was that it was available for members of the public who lived in Bedford and the surrounding areas of Bedfordshire. It was set up for individuals who couldn't afford to pay privately or who had difficulty accessing legal advice. However, since the clinic launched, you know, the clinic does get quite a few inquiries from clients who geographically are not located in Bedford. And let's face it, Rashid, I am not going to turn a client away just because they don't live in Bedford. Where a client really urgently needs advice, it's an emergency situation, we have accommodated and the clinic has given advice to clients who live in London, Manchester, Devon. So, where we have capacity and where we have availability, we will accommodate. The clinic is usually open 2 days a week, for a couple of hours. Sometimes, I have taken clients outside those 2 days, especially if I feel it's an urgent situation where they require advice, ASAP.
Of course not. And that makes sense, right? Because the law, it's the same law you get across England, right? So regardless of your geographic location, and if it's advice that needs to be delivered remotely or can be delivered remotely, geographical proximity shouldn't be relevant at all.
Yeah, No, I totally agree. So, that's why it is available, nationwide, should somebody want, access to legal advice.
How complicated is the divorce process? And is it something people can complete themselves?
Okay, now I would probably say the divorce process is fairly straightforward, but I probably would say that because I am a divorce lawyer, and for me it's the norm. But what I would say is on the 6th of April 2022, the no fault divorce process was implemented, and one of the reasons it was implemented was to simplify the divorce process. So prior to 6th of April 2022, if you wanted to apply for a divorce, you could only apply under certain factors such as unreasonable behaviour, adultery, 5-year separation. That effectively now no longer. And since the 6th of April, couples can issue divorce proceedings simply on the basis that the marriage has broken down irretrievably. There's no need to give any reasons as to why the marriage has broken down. There's no need to provide any evidence. Where couples are fairly amicable, they have the option to make a joint application. A divorce can no longer be contested, and the divorce can also be applied online. So, yes, potentially, if you are computer savvy, then you can complete the petition yourself, and information on how you can apply online can be accessed by going on the gov.uk website.
Thank you. We'll just pick up two of the questions here from the audience. The first one is, what is a Mackenzie friend? And the second are there any disadvantages of using one?
Okay, so a Mackenzie friend essentially is either a layperson or a professional who provides moral support to litigants in person at court. So, technically, where you are involved in court proceedings and you have a court hearing and you're not legally represented, you can technically take a Mackenzie friend along with you. Now, I think they're very useful in providing support. However, there are certain things that Mackenzie friends can and cannot do. So, some of the things that a Mackenzie friend can do, for example, is they can, take notes, they can give you suggestions, they can give legal advice, but quietly, because what they're not allowed to do is they can't go before the judge and speak on your behalf. They can't cross examine witnesses, and they can't act as an agent. So, if it is a case of, where you're quite apprehensive of going to court, I'm of the view that they can be quite useful.
And the advantage essentially it's support, and I assume the advantage of using a Mackenzie friend over a solicitor essentially is in cost savings. Is that it?
Well, basically, it's mainly, when you get legal representation, you've got a lawyer who's legally there representing you, legally knows the law and the procedure, and a Mackenzie friend is more there to kind of hold your hand and support you. So I think, you really need to be aware, when you have a legal lawyer and when you have legal representation, your lawyer will be the one that addresses the judge and talks on your behalf and represents you in accordance to your instructions. And a Mackenzie friend essentially cannot do that because they don't have rights of audience. So, if you're looking for some moral support, they're useful. However, if you want someone legally to represent you and argue the case on your behalf, then my advice would definitely be is to make sure you've got proper legal representation.
Thank you. Very helpful. Just kind of, I think, could pivot from that. We get quite a few questions from people as to what the divorce process would cost them,
Mhm.
and if you could shed some light on how just divorce costs are structured.
Okay, so it very much depends in terms of whether you're planning to do the divorce yourself or whether you're instructing a lawyer to help you deal with the process. Usually, if you're planning to complete the divorce petition yourself, then you need to be aware that there's a court fee to pay to issue the court petition. And that court fee has recently increased to £652. So essentially, if you're going to represent yourself, that technically is one of the costs you need to be aware of. If you potentially are looking for a lawyer to deal with the divorce on your behalf, because the process does involve completing paperwork. And once you start the process, there are various stages thereafter which you have to complete. And so, usually, most law firms fixed fee costs to deal with the divorce from start to finish. And those costs can range anywhere between £600 plus VAT up to £1,000 plus VAT. If with the finances, just because of the complexity involved, usually it will be an hourly rate. Sometimes, clients can get just some initial, one-off advice from lawyers, and those consultations again can take place on a fixed fee basis, and they usually start from around about £200 plus VAT onwards. So, if it's just a divorce, like I said, most firms offer fixed fee costs for that.
So about 620 something ish pounds for the court fees plus VAT for the court fees. Sorry, Gonia.
Oh, sorry. So I was going to say, so there's no VAT for the court fee. So it's 652. So there's no VAT payable on that. But if you do then go potentially for a fixed fee package, which range around about 600 or £700 plus VAT, then it's up to around about 1,000, 1,500 possibly.
Is this something is legal aid available for this?
So I actually, Rashid, don't specialise in legal aid, but as far as I'm aware, legal aid generally isn't available for divorce unless you can prove that you're a victim of either domestic violence, which includes financial abuse. However, my advice would be, where somebody believes that they potentially might be eligible for legal aid, it's best to contact a legal aid lawyer and speak to them, and they would be in a better position to advise you as to whether, you're eligible and you meet the criteria for legal aid.
Is there a way to mitigate or reduce these costs?
So there are a number of ways. I mean, so say, for example, a couple is thinking of applying for a joint application, okay, and where they're thinking of instructing a lawyer to deal with the application and the divorce process, the couple might decide that, it might be easier just to split the legal costs between them. So that's one possible option. Another possible option is to, again, split the court fee between themselves, or say, for example, if one spouse is making a sole application, and they are legally represented, it might be the case where they pay for those legal costs and then the other spouse meets the court fee. Another possibility is where you're on benefits, where you're on a low income and capital. When you're applying for a divorce, you can make an application to the courts for them to assess whether you're exempt from paying the court fee. So when you make the application, the court will then assess your income and your capital, and they will then revert back to you to confirm whether you're exempt from paying the full fee in its entirety or whether you have to pay a reduced fee.
It's very helpful. Have you heard of the Ashraf Hakimi and Hiba Abood divorce? I think sometime last year.
Yes, I mean, I wouldn't say that I know all the ins and outs of it, but yes, I am aware of that case.
So for the audience, yes,
Mhm.
Ashraf Hakimi, as football fans would know, Moroccan footballer, does very, very well. Married a Spanish actress, Hiba Abood. Sometime, I think it's last year, they separated and the missus filed for divorce. So
Mhm.
Ashraf Hakimi is worth circa 70 million something. I'm sure, she's assuming,
Yeah.
pot, just, a joint property, walk over 35 million-ish. When she filed for divorce, Ashraf
Mhm.
Hakimi comes to court and he's like, "Oh, listen, by the way, I don't own anything." They, "What do you mean?" And turns out everything he had was in his mother's name. So all the houses, all the cars,
Oh, wow.
and the court agreed. The court's like, he doesn't own anything. So rather than him giving his wife something, right? I think she had to pay him, And that's just kind of what happened there. Firstly, what your thoughts are on this, and secondly, this was a French court. Do you think, if this was happened in England, they would have this, the court would hold the same?
I can honestly say that if this case was being tried, under the UK jurisdiction, I think the outcome would have been very, very different compared to the decision that was made in the French courts. I mean, here in the UK, the family court, especially when it comes to finances, they have a fair bit of discretion. They will take into account all the factors, of a case, and that there are certain specific factors that they do take into account when they are considering how assets should be divided and distributed between the parties, where essentially there's a dispute between them. I think, here potentially, if it was being dealt with under the UK courts, the wife potentially would have had, a strong argument, where even though legally all the assets were in his mother's name, one could potentially argue that beneficially they were all his. Another strong argument that could have possibly be taken into consideration is the issue of conduct, in the sense of, what was the reasoning behind the whole setup of, all his assets being legally put under his mother's name. Was that deliberate on his part, so that potentially it would keep those assets out of the wife's reach, so that it would defeat any financial claims that she made. And I think, within the UK courts, I think the outcome would have been very different, where potentially, the wife definitely would have walked away with something from that 70 million, that he has. But having said that, I obviously specialize in the UK. I'm aware of, what clients potentially are entitled in the UK. I don't really have much knowledge about, France and the way they deal with matters. But I mean, from my personal point of view, and like I said, Rashid, I don't really know all the ins and outs of this particular case. But when I read it, and when I thought, oh my God, this is what the judge found, as a lawyer, I was initially like, oh my God, that just seems so unfair. Like, this can really happen, because I think, it's kind of quite apparent to everyone, like why would you put them all in your mum's name? So yeah, it is what it is. And that was the finding that was made. But like I said, I think the outcome, if it was being tried in the UK courts, if they did have the assets here, would have been very different.
So I, ages ago at this point, I studied with some French lawyers, and
Okay.
what I recall from then is that French law, civil, more codified system. So court system has less discretion in how they operate. I assume we operate a common law system, right? So courts have a lot more discretion into how they award judgments. A
Yeah.
very odd piece of news. Yeah, I found a very odd piece of news as well.
I just found it so, and I just found it so unfair. Like, oh my God, like really? But like I said, because like I said, legally he might have put them in her name, but benefit, who's the one that's going to benefit from them, and who's enjoying them? So it's all that. But yeah, that was the outcome.
For individuals who, I know we touched upon this earlier, but
Okay.
for individuals who would like to file for divorce themselves,
Mhm.
what does the process look like?
Okay, so like I said, if a client is potentially thinking of applying for the divorce, they can apply online, and they can access that information by going onto the gov.uk website. Two things that clients need to be aware of when they're potentially going to complete the application online. Firstly, is that they need their original marriage certificate, because when you submit your divorce petition, you need to upload your marriage certificate. And I suppose the other thing you need to make sure is that you've got the relevant funds to pay the court fee. Where you're not that computer savvy, it's my understanding that you can make a paper application by post. And again, that information can be found by going on to the gov.uk website. So where you're planning to issue a divorce petition, that person potentially is known as the applicant. and the person who's going to be receiving the divorce papers, they are known as the respondent. So when you apply for a divorce online, once you've submitted the application, the courts will usually issue it and serve it upon the respondent. The respondent then usually has around about 14 days to submit a response. And then thereafter, the applicant needs to wait a period of around about 20 weeks before they can apply for the next stage, which is the conditional order. Now, prior to the 6th of April 2022, the conditional order was known as the decree, has now changed and it's now known as the conditional order. Once you make an application for that, and providing that's been granted by the courts, you then need to wait around about 6 weeks before you can apply for the final order, which was again previously known as the decree absolute. And it's only when you're granted the fine that's when you're officially your marriage is officially dissolved. So usually the process can take around about 6 months, providing there's no delays. However, where financial matters need to be resolved arising out of the divorce, I always advise clients not to apply for the final order until a resolution has been reached over the finances, and once that's been dealt with, then it's usual at that point to apply for the final order. And so if you do make an application online, then what the courts usually do is throughout the whole the courts will usually notify you, in terms of when you can apply for the conditional order, when you can apply for the final order. So it's fairly transparent.
What is something you wish people knew before getting married? And what's something you wish people knew before getting divorced?
So with marriage, I'd probably say just don't get married. Just don't get married. But no, I think one thing I will probably advise couples to think about is potentially exploring or considering whether a prenuptial agreement is required. So this essentially applies to couples who are planning to get married where there possibly is a clear disparity in terms of the capital that they have, especially where one person has quite a bit of assets that they've accrued prior to the marriage and the other person hasn't. Or say, for example, an individual has a business or it's their second marriage. They should consider a prenuptial agreement, because what a prenuptial agreement technically does, Rashid, is it's an agreement which sets out, how the assets will be distributed and divided in the event a marriage breaks down. I mean, it doesn't sound romantic, I totally get that, but I think it's very, very sensible, and it can save a lot of costs later on down the line if couples have that in place. So I would potentially advise clients to, couples to explore that possibility. In terms of somebody who is thinking about a divorce, planning a divorce, I can't emphasize how important it is to get some initial legal advice. Even if it's a fixed fee consultation, I think it's really, really important to get some initial advice about the divorce process, about the court process, how that would work if you can't agree matters, financially, what you potentially might be eligible or entitled to. Again, that can save a lot of headache where somebody doesn't know what they're doing and they start the process blindly and make numerous errors, which then make it difficult for any lawyer then to sort it out on their behalf. I have numerous clients who sometimes come to me who have done certain things or have made certain decisions which they probably would not have done had they had that initial sensible advice from the outset. You have so many clients who say they searched it on Google, they heard from a friend's friend, they heard from a hairdresser, they heard from their mechanic. I'm sorry, none of these people are legally qualified. If they were, they would be lawyers. And so I can't emphasize the importance of how important it is just to get that initial advice. It will save you so much hassle, if you then decide to, go down that process, and then you kind of decide, well, you're going to do it yourself, because at that point you're kind of already aware of how the process works, what it entails, and what you potentially are legally entitled to.
So this is, I think, quite a common theme we get from most lawyers we speak to, and that's essentially get advice at the earliest possibility. And the reason is, if you make mistakes, right, rectifying them later on is very challenging. So it's a
Mhm.
lot. Even if you don't want to use legal services in the process, you want to do them yourself, do the process yourself. Just obtain legal advice at the start, and that allows you to kind of plan that delivery better.
You've hit the nail on the head precisely. I mean, as I've said before, if, say, for example, you file a divorce petition and it's been submitted incorrectly, you then have to take steps to amend the petition, and that can be you know quite a fair bit of a headache, to kind of get that resolved. It can cause further delay. So yes, where you're equipped from the outset, it can save a lot of delay, and it can avoid certain, happening.
Of course. We're going to pick up one of the questions from the audience, which is quite relevant. So it's essentially, what are the legal requirements, if any, of a prenuptial agreement?
So, I mean, with a prenuptial agreement, I think, with the prenuptial agreement, you've got to be aware that it isn't potentially legally binding. However, the courts do attach considerable weight to it, depending on certain requirements being fulfilled. Some of those requirements, for example, include, whether or not the parties have had the opportunity to obtain legal advice, whether prior to the prenuptial agreement being made, whether both parties have exchanged financial disclosure so that both parties are aware of each person's assets, their income. Again, another factor that the court takes into account is when the prenuptial agreement, for example, was implemented. They want to make sure that neither party was kind of forced or was subject to pressure in terms of signing it. So, the more time you have in terms of, when it's signed, and before the marriage takes place, the more weight the prenuptial agreement holds. Because if, say, for example, you sign a prenuptial agreement the day before you're getting married, or a week before you're getting married, there might be an argument that, one party was subject to certain pressure. So, there are certain conditions that need to be fulfilled, which will then hopefully attach more weight to it if later on one disputes the prenuptial agreement and its validity.
Thank you. Now, very helpful, very comprehensive. At the clinic, do you get a lot of child custody disputes? And if so, could you provide an example?
So yes is the answer to the question. I mean, most of the disputes we have in respect to children matters usually involves parents who have separated, and the issues always revolve around contact, where one parent is making it very difficult for the other person to get regular contact and to have regular access with their child. The clinic also gets quite a few inquiries where the parent just wants to know what their legal rights are, because the primary parent is potentially excluding the other parent for various decisions over the child's welfare and upbringing. And so they usually want to kind of know what their legal rights are, what they can and cannot do, and how they can potentially get regular and consistent contact with their child.
Do you find there's a difference in treatment of these disputes, whether the parents are married or not married? And this from the perspective of both,
Sorry.
I assume, both the social workers or CAFCAS.
So I would probably say no, there isn't a difference in treatment. Whether you're married or not, from a court's point of view, from all professionals such as CAFCAS, the main priority and the main focus is the child and what is in a child's best interest, and from a court's point of view, where they have to deal with applications where there is a dispute over a child's arrangements in terms of residence, in terms of contact, the courts take the view that it is in a child's best interest for the child to have regular and consistent contact with the non-resident parent, and because it is in a child's best interest, and contact should only be approached with caution, say for example if they are safeguarding concerns. So in these kind of applications, it's not even a parent's right, it's a child's right. It's a child's right to be able to have a relationship with both parents, and to get to know both sides of the family in the event couples do separate.
If a couple are splitting and have children, any tips as to what they should do and any steps they should take in particular?
I think it's important from the outset, if you are separating, to maybe open up a clear dialogue of communication to see if you can kind of, reach an agreement between yourselves in terms of, you know, what kind of contact will take place, see if you can kind of agree on what the arrangements will be in terms of stay in contact, in terms of holidays, and where, say, for example, you are at loggerheads with each other, possibly think about, getting professionals involved, such as exploring the possibility of mediation, so that a neutral third party can potentially assist you in trying to resolve whatever issues you're having, because that potentially can then save you a lot of money, and avoid you issuing, court proceedings, because, if you do issue court proceedings, it can be, fairly expensive.
And I'm sure quite traumatizing for the children as well, right? Because just a lot more of a dragged out process, seeing both your parents just kind of, in that space. Any advice for people splitting as to how not to let the divorce affect the children?
So I personally think, Rashid, I mean, you know, when a couple is divorcing, it will always have an impact on the children. I think the important question is how you minimize that impact. And I think, one of the most important things that couples really need to do to avoid and to minimize that impact is to make sure that they are not discussing any adult related issues in the presence of the children. Children are like sponges, they take everything in. And where you're having adult related conversations about the finances, if discussions become quite heated, it's going to have an emotional impact on your child. So where possible, just avoid those conversations. And where discussions are taking place, where they are becoming quite heated, one person really needs to take the incentive of either leaving that room or leaving the property, so that matters can kind of calm down. Because, you know, if children are exposed, to that conflict, it will have an impact on them. Like, for example, I was representing a client in respect to contact matter. The parents were at loggerheads over the contact arrangements for the children. And, there was a lot of conflict within the family home, where the father in particular was very verbally abusive to the mother. There had been some physical altercations. All those incidents had been witnessed by uh, the children, and the youngest child in particular was impacted in the sense that it was affecting her progress at school. She was behaving quite aggressively towards her teachers and to her schoolmates, up to the point where an incident occurred where she threatened another pupil, saying that she's going to stab them. And that was as a result of her witnessing an incident probably 2 days before, with the parents, where the father has said something similar to the mother. So, you really need to be careful, because, in the long run, I think what couples need to appreciate is, once you've set, if you've got children, you're always going to be a part of each other's lives because of these children. They're going to have milestones in terms of their birthdays, in terms of when they graduate or when they get married. So it's important to try and be amicable as possible from the outset, to avoid further difficulties and challenges occurring later on, with your children, where they then go on to display either challenging behaviour or go on to form dysfunctional relationships because of what they've witnessed, and then at that point, that couple and those clients will need to take some accountability for it.
Yeah, I think quite profound advice. And even though divorce, separation, I'm sure is an extremely painful process, very important to keep in mind that I'm sure every no parent wants it to adversely affect their children. So just putting them first and in everything else second, I think extremely important. This has been really helpful, and I'm sure it's been really helpful for the audience as well. A final question from myself.
Mhm.
Could you share, like, what's been the most interesting case you've worked on?
Okay, so as a family lawyer, I've probably dealt with a number of interesting cases over the years, but one that I can potentially think of is one where I represented an applicant wife in respect to financial remedy proceedings. So very briefly, Rashid, this was a case where the parties had been married for around about 10 years. They had two minor children aged 13 and 7. In respect to the finances, there was a family home that was co-owned 3 ways with husband's mother, who had a 40% share in the property. The family home was valued at around about 850,000. Husband and wife also had a property business, which they were joint directors of. Husband also had a construction business with his father. Again, they were joint directors. And that business in particular was doing financially well, in terms of the profits it was generating, in terms of the assets. We then issued divorce proceedings. When it came to the finances, they were unable to reach a settlement through negotiation. A lot of that was because of husband's lack of transparency in relation to his finances. We then issued a formal application to the courts to get the finances formally resolved. During the court proceedings, husband alleged that the construction business with his father was no longer doing well because of the COVID-19 pandemic. Our client did a bit of digging, or shall I say, we did a bit of digging, and it then emerged that shortly before the parties had separated, husband's father had set a new company in construction in his sole name. We then made a disclosure application for third-party disclosure to get some information about that new company. It then became quite apparent that all the work contracts were being put through in the father's company. The subcontractors were being put through under that new company. Assets in both businesses were being intermingled. We then had a financial dispute resolution hearing before the judge, and at that hearing, the judge indicated that husband's conduct was a real issue, where it appeared that he had deliberately deflated his income and assets as a means to keep them out of wife's reach and as a means to defeat her financial claim. And the judge made it quite clear that, if the parties didn't reach a settlement and if the matter did go to a final hearing, then husband technically would be penalised in respect to any financial settlement that was awarded to the parties. Now, whilst this was going on, husband's mother was also joined as an intervener in these proceedings because there was a potential dispute over her share in the property. However, thankfully, we managed to get that resolved by agreement. And then during this this same time, we then had to also issue Children Act proceedings because the parties couldn't agree the arrangements for the children. And then, whilst those proceedings were also going on, we also then had to issue proceedings under the Family Law Act for injunctive orders to protect my client because of the husband's behaviour. So, matters were escalating in the sense that he was being, extremely abusive, making threats of harm. He was following my client, harassing her. And so we made an application for emergency orders for a non-molestation order and an occupation order. Those were granted. Husband then filed cross applications, making an application for a non-molestation order and an occupation order against my client. And so we technically had 3 sets of court proceedings going on at the same time. And for me, I kid you not, Rashid, there was a lot of, deadlines to me, a lot of pressure to deal with various court hearings. Everything, practically escalated in this case. But thankfully, we did manage to conclude matters. With the finance, the case was actually listed for a 5-day court hearing. However, a month before the final hearing, the parties did reach a settlement where my client walked away with a substantial lump sum, which enabled her to rehouse herself and the children mortgage free. The lump sum also reflected, husband's conduct, and so some compensation to her. But yeah, that case kept me on my toes. I mean, I had that client for 3 years. I mean, imagine, 3 years, the rapport that I had built with her, and so yeah, dealt with everything, for her. So yeah, that was very interesting. But sometimes that happens in family cases where you're potentially dealing with one matter, and before you know it, you're then dealing with X, Y, and Z at the same time.
That doesn't sound like a family case. That sounds like a Lehman Brothers bankruptcy, right?
No, Rashid, you're right, because the costs in this case, oh my God, they did escalate. And a couple of times, when we were at court, especially in the finances, the judge was extremely concerned about, the costs that both parties had incurred, and, what the costs, were going to be, at the final hearing. I mean, for a 5-day final hearing, trust me, in terms of, having barristers preparing final statements, it was absolutely horrendous. So thankfully, they did save a fair bit of money in that respect. But, prior to that, a lot of money had been spent by both of them.
Sounds like quite an interesting case, right? Quite an
Yeah,
interesting.
it was. Yeah, definitely.
Geeta, we're just about at the hour, so I'm going to wind up. Thank you so
Mhm.
much for taking out the time and joining us, having this lovely conversation with us. And we look forward to having you with us soon. Thank you to the audience for joining us and listening to this. We hope we've added value to your evening and just your knowledge in this space. Have a fantastic evening, everyone. Take care. Bye bye.
Thank you. Bye.